The insurance adjuster just offered you $20 a day for loss of use while your $100,000 vehicle sits in the shop. Have you ever felt completely shortchanged after an accident that wasn't your fault? Stop right there. Don't accept that offer. This standardized rate established by insurance companies is like paying for a luxury watch at dollar store prices. It's one of the insurance industry's most profitable tactics, and it's costing you thousands. Loss of use isn't about some arbitrary daily rate. It's about the actual daily rental value of your specific vehicle. For luxury vehicles, specialty trucks, or commercial vehicles, the difference can be staggering. By the end of this video, you'll know exactly how to calculate what your claim is truly worth.
Red Rock Injury Law, Las Vegas. Rock! Solid recovery! Solid recovery! Rock! Red Rock!
Myth number 1. Have you ever had an insurance adjuster tell you, no rental car receipts? Sorry, no compensation for the loss of use. This common tactic leads many accident victims to either unnecessarily rent vehicles they don't need or abandon legitimate claims worth hundreds or even thousands of dollars. Let's break down what the law really says. Under Nevada law, the fundamental principle is clear. Compensation is about your right to use your property, not whether you actually exercised that right. The Nevada Supreme Court has consistently recognized that vehicle owners deserve compensation for being deprived of their property, regardless of whether they obtained a rental. The landmark case, Dugan v. Kostopoulos, specifically held that a vehicle owner can recover damages without showing they actually rented a substitute vehicle. The court recognized that the inability to use one's property represents a genuine loss deserving compensation. This creates a dilemma for many accident victims. Some people borrow vehicles from friends, use public transportation, or adjust their schedules. Others can't afford upfront rental costs, especially when insurers require them to pay first and get reimbursed later. None of these situations should prevent proper compensation. The principle applies regardless of whether you use your vehicle, whether your car is for business purposes or personal enjoyment. Nevada law recognizes the intrinsic value of your property rights. I recently helped a client who didn't rent a replacement after an accident. This client had a second car. After we cited the relevant Nevada case law, the insurer provided appropriate compensation based on the vehicle's rental value. Myth number 2. What if I told you most injury victims should receive double or triple what they actually receive, even when represented by an injury law firm? This widespread practice of standardized payouts reflects another deceptive insurance tactic that costs accident victims thousands in rightful compensation, and many law firms don't even realize it. When you file a loss of use claim, insurance companies typically offer the same fixed daily rates, usually somewhere between $25 and $50, regardless of your vehicle type. But legal reality does not match this oversimplified approach. It's like paying premium prices for tailored services while only receiving generic compensation in return. Nevada law requires compensation based on the market rental value of a comparable vehicle to yours, not the insurance company's contracted rate with Enterprise. This distinction is significant. While an insurance company might offer you $30 daily for your loss of use, the actual rental costs for your specific vehicle could be substantially higher. For luxury vehicles, specialty cars, or high-end SUVs, daily rental rates can reach hundreds of dollars. In fact, the highest daily rental rate that I have recovered for a client was nearly $1,000 per day. Courts have consistently reinforced this principle of fair compensation. Numerous judicial decisions have established that fair and reasonable compensation means the actual rental value for a similar vehicle, not whatever rate benefits the insurance company's bottom line. If your rental vehicle has a true rental value of $250 a day, but the insurer offers just $50, you're losing $200 every day your vehicle remains unusable. This $200 daily difference adds up fast. To protect yourself, independently document your vehicle's actual rental value by obtaining quotes from rental companies for comparable vehicles. When challenging an insurer's offer, present this documentation professionally while referencing Nevada legal precedent that establishes your right to compensation based on comparable rental values, not standardized rates. Myth number 3. Understanding your rights to fair compensation is critical, especially when facing another widespread misconception that costs accident victims dearly. Did you know that in Nevada, a vehicle declared a total loss can still qualify for loss of use compensation, potentially for weeks longer than insurance companies want you to believe? When an insurance adjuster tells you that loss of use compensation only applies to vehicles being repaired, they're deliberately misleading you. This tactic specifically targets owners of totaled vehicles that are suddenly stranded without transportation, often abandoning thousands in rightful compensation simply because they believe their claim ends once the vehicle is declared a total loss. In reality, Nevada protects your rights even when your car is totaled. The law recognizes your entitlement to compensation during the entire period you're without your vehicle, from accident until you reasonably secure a replacement. This timeframe extends far beyond what insurers typically acknowledge. The actual replacement process involves evaluation, value negotiation, research for options, securing financing, and purchasing a suitable vehicle, often taking many days or weeks while you struggle with disrupted work commutes and daily routines. All this warrants compensation. Insurance companies artificially shorten this time frame, offering compensation for just days after settling your claim, contradicting legal precedent that requires the entire period of deprivation, including reasonable replacement time. Protect yourself by documenting your vehicle replacement journey, communications, appointments, applications, and search efforts. Create a timeline showing your diligence, noting any reasonable delays. Reference that courts consistently recognize the entire replacement process as compensable, ensuring you receive full compensation for your complete loss of use. Myths number 4 and 5. Those replacement delays we just covered aren't the only aspect of loss of use claims that insurance companies misrepresent. What if I told you that a Ferrari owner and a Kia owner are legally entitled to dramatically different compensation amounts, despite what insurance companies routinely claim? When adjusters handle your claim, they typically apply standardized daily rates regardless of your vehicle type, a fundamental contradiction of Nevada law. The law recognizes each vehicle's unique value based on market rental rates. Luxury and specialty vehicles command rental rates of hundreds of dollars a day, while standard vehicles rent for $25 to $50 per day. This difference is like comparing a 5-star hotel to a budget motel. Both provide shelter, but at vastly different values. By accepting the at-fault insurance company's standard rate for your premium vehicle, you could be leaving thousands of dollars on the table. Insurers also artificially shorten your compensation period. They claim that loss of use only covers a maximum time, like 30 days, or the physical repair time, ignoring the legally protected comprehensive timeline. Consider this scenario that happened to a client with a Mercedes that needed a specific part from Germany. Unfortunately for my client, this happened during the pandemic, and it took months for the part to arrive. In total, the Mercedes was in the shop nearly 5 months. The insurance company only offered payment for 25 days of a rental at their standard rate. For totaled vehicles, the principle also applies. Insurance companies often try to enforce a 3-day cutoff period for a rental or loss of use. While they may be able to enforce this limit when it is a contracted for provision in the insurance contract of their insured, it doesn't apply to situations when their insured caused the accident. The reasonable time to research options, secure financing, and find a replacement can all count toward your compensable period. Many insurers cut off compensation after 3 days have elapsed after issuing the settlement check, but Nevada law contains no specific provision that allows for this 3-day cutoff. Being mindful not to abuse this rule, however, you do have to be making a reasonable effort to obtain a replacement vehicle. Protect yourself by documenting every step of your vehicle's repair or replacement journey. These records become invaluable when challenging an insurer's abbreviated timeline. So now you have all the facts you need to calculate your true loss of use value. Simply multiply your vehicle's actual daily rental rate by the number of days that you were deprived of your vehicle. Remember, every day counts. Challenge that first offer. Industry studies confirm people who do receive up to 40% more compensation than those who immediately accept. Insurance companies count on you being uninformed or too tired to fight. Document everything meticulously, repair timelines, rental quotes for comparable vehicles, all organized to show the insurance company that you know your rights. If you're still facing resistance, don't hesitate to consult with a Nevada attorney experienced in auto property damage claims to ensure that you receive every dollar you deserve under Nevada law. Just click on the link in the description to schedule a call.